Hello, everyone, and welcome to today's Fenwick Elliott webinar. My name is Stacey Sinclair, and I'm a partner here at Fenwick Elliott. We are delighted to be back here again with you today. Today actually is an anniversary for us. It marks 4 years since we've started the webinar series. That was back on the 16th of May in 2020 during one of the COVID lockdowns. It was an adjudication update, actually, and we are very, very pleased that we're still going strong today. And that is very much thanks to you, our audience, who continue to join, show interest and provide feedback, which is ever so helpful to us. So thank you very much for joining today, and welcome. So turning to today's topic, there we go. Turning to today's topic, we of course have the Building Safety Act and keeping you up to date with the recent developments and where we're at. Now, the last building safety webinar we had was back in October of 2023, where Ben Smith and barrister Samantha Jones took us through the Act and the developments and the case law as it was at that point. So if you're interested in that session, please do feel free to go to our website under Research and Insights, and you will find the slides and the recording of that session there. And so today's session will bring us up to date since then in respect of the Act and recent case law and what we might expect to see on the horizon. And to do so, I'm very delighted to introduce to you our two speakers today, our very own Ben Smith, welcome back, and Hugh Wilkins, both of which are senior associates here at Fenwick Elliott and specialize in construction and energy law and all forms of dispute resolution and dispute avoidance, and the Building Safety Act being very much close to their heart. So welcome, Hugh and Ben. Just a few points to note as usual. Please do submit your questions as we go. You'll find the questions bar on the toolbox on the right-hand side there. Please do submit your questions as we go. And of course, a copy of the slides and an on-demand recording will be available on our website in due course afterwards. So with that, Hugh, Ben, over to you. Thank you very much.
Thank you very much, Stacey. As Stacey says, we've previously covered various parts of the Building Safety Act. The last session we gave very much focused on duty holders and competencies and the gateways, some more of the front end changes. Today, we are going to focus on some of the more recent case law coming out of both the TCC and the First Tier Property Tribunal, and consider the impact that is having and will have in the future on parties that either find themselves on the receiving end or find themselves bringing claims in this new environment that we are in. So just in terms of the agenda for today, just quickly skip back a slide there. We are going to look at very briefly the regulations now that the transitional period has ended and what that now means. We're also going to look at I'm going to speak about the two recent decisions in the First Tier Tribunal, so Triathlon Homes and Get Living, and then also the very recent decision, which is the Secretary of State for Homes, Communities and Levelling Up against Grey PR, who were the landlord. And then Hugh is going to talk about two recent TCC cases, actually one in the Court of Appeal, URS and BDW, and Wilmot Dixon and Prater Homes. So just very quickly, I just wanted to touch on the end of the transitional period. As you may be aware, under the Building Safety Act, which is largely, although not solely, a piece of enabling legislation, a number of rather significant secondary pieces of legislation have been brought in. I've put them up on the slide there just because it occurred to me that it's quite nice to have a summary all in one spot of what the various regulations are and what they relate to. I think the ones that you will be most familiar with, or perhaps need to be most familiar with, are the first one, the Building Regulation Amendment England Regs 2023, which deal with the amendments to the building regs and apply to all buildings, including high-risk buildings, and they set out the new duty holder and competency regime. And then the third one there on the slide, the High-Risk Building Procedures England Regs, I'm afraid none of them have particularly memorable titles, which is the building control, sets out the building control regime for higher risk buildings, and within that deals with the new gateway provisions, the golden thread, how change control is to be managed on high risk building projects, mandatory occurrence reporting, all those new obligations which have now come into force. And just quickly, actually, on the end of the transitional period, I mean, what that means now is that any new building undergoing HRB work being the new construction of an HRB building, the change to an existing building to make it an HRB, so for example, by adding an extra story, or a building that undergoes some form of material change to make it an HRB. So if you're converting something that was previously office space to residential space, which you may remember there was quite a push for, certainly in and around COVID, and off the back of COVID, it was thought that office space would reduce and residential space would be put, or it would be converted in its place. Those are the types of buildings that are now caught by the gateway provisions. It doesn't include work to existing HRBs. There is a separate process that you have to go through for that under Regulation 11 of the High Risk Building Procedures Regs. And then the duty holder and competency regimes apply to all buildings. I'm not going to spend much more time on that. If you do have any questions, though, at the end, feel free to ask. And then I just, as a kind of precursor, before we get into the case law, I wanted to set out the changing landscape for claims that we've really seen in the past 18 to 24 months with the advent of the Building Safety Act. I mean, slightly glib here, but before the BSA came along, we had that kind of green and pleasant land, if you like, of everyone knew where they stood. You know, you needed a contract if you were going to bring a defects claim, largely because the use of the Defective Premises Act was rather limited, because it only had a 6-year limitation period and only applied to new builds. Claims for in negligence, I think, were rather limited in relation to defects because of the issues around pure economic loss. Corporate separation still existed, if you like, so parties were able to limit risk by ensuring that only certain companies were those carrying out builds, of kind of the traditional developer model, if you like, of having a shell company carry out a new build. You'll see there the kind of traditional limitation periods, 6 years under the DPA and 12 years under contract. And we had an array of causation and quantum defences. So, for example, you know, other parties have contributed to this defect, or, you know, that party in correcting these defects has failed to mitigate its loss, points like that. Now, under the BSA, we've got the new routes to claims. So we've got the amendments to the Defective Premises Act and the extent so that it applies to both new dwellings and existing buildings. So it applies to refurbs or works done to existing buildings. We've got the additional 2 routes of claim under the BSA itself, sections 148 and 149, in relation to construction products and cladding products. We have got the threat of section 38 of the Building Act, which will apply to any breaches of building regs, albeit that still hasn't been brought into force. We have got BLOs now, building liability orders, which Hugh will talk about in a bit more detail today, but effectively they allow parties to make applications to the court to go behind the corporate veil, i.e. look at parties, associated companies and or parent companies, to get to the party that has the deeper pockets. Limitation periods are now much longer. You've got 30 years retrospective under the DPA and 15 years prospective. You've got 15 years prospective periods under the new routes to claim in the BSA. And following the cases of Martlet and Mullally and LVC and Downing, which are a couple of years old now, it's much harder to run some of those usual causation and quantum defences. So I think that's quite useful background and kind of shows the direction of travel more generally, and will give a bit of helpful context to some of the points that me and Hugh are going to discuss during the rest of the webinar. So the first case that we're going to discuss today is Triathlon Homes SVDP, Get Living PLC, and EVML. This case is concerned with the former Athletes Village, so it concerned 5 residential buildings in Stratford, originally developed by SDVP, and were part of providing accommodation for 17 athletes and officials during the 2012 Olympic Games. At the time of the development, as it says there on the slide, SVDP were owned by the ODA, the Olympic Delivery Authority. And then, as you may well recall, after the Olympic Games, part of the purpose when building those buildings, they would be eventually sold and used to provide residential housing in East London, as well as various kind of affordable homes. So after the Olympic Games, SDVP is sold and is now owned by Get Living, which is the second respondent, and the former Athletes Village is now known as the East Village. May not be as glamorous as New York, not casting any aspersions on Stratford, obviously, and is now a large permanent residential estate. And Triathlon is a limited liability partnership that was established to provide affordable housing in the Athletes Village. And then the repair and maintenance of those 5 structures and the common parts was the responsibility of the third respondent, which is East Village Management Company Limited, and that's jointly owned by Get Living and Triathlon. And so this case concerns a remediation contribution order. And so just as a quick reminder, excuse me, remediation contribution orders are provided for under Section 124 of the Building Safety Act, and effectively they require a relevant landlord or a relevant party, it can be a landlord or a past landlord or a developer or a past developer, to contribute to the cost of remedying defects in a relevant building by a specified time. In the case of Triathlon, serious fire defects were discovered in November 2020, and remediation plans were drawn up, which were due to be completed 5 years later at a total cost of 24.5 million. Triathlon issued 5 applications in total against SVDP and Get Living as the associate of the freeholder of the blocks for remediation contribution orders under Section 124 of the BSA, asking for a contribution of nearly £18 million towards the remedial works. Now, the FTT took the approach of bundling all those 5 applications together simply to reduce time and cost, and ultimately granted RCOs against SDVP and Get Living, ordering them to make substantial payments, which is set out there on the slide, the largest one being 16 million to EVML in respect of the major works. And I suppose that's the first interesting point about this case. So while the application is brought by Triathlon, part of that application was Triathlon asking for money to be made available to EVML because they are the party that was responsible for the maintenance and repair of the blocks. So it's ensuring that they have the money to carry out the remediation. So parties are, it's not limited in terms of whether payment will be made to the claimant in the proceedings or whether it will be another party. And then a number of interesting points come out of this case. The first one is whether can a remediation contribution order be made in respect of costs incurred pre-BSA, pre the commencement of the BSA in 2022. So SDVP and Get Living argued that a remediation contribution order could not be made in respect of costs incurred pre the commencement of the BSA, and the fact that costs had been incurred before the date of commencement was a reason, or at least a contributory reason, why it wouldn't be just and equitable to make such an order. Now, it may come as no surprise, but the tribunal roundly rejected these arguments. They said that there was no doubt that Section 124 allowed remediation contribution orders to be made in respect of costs incurred before the 28th of June 2022, being the commencement date of the BSA. And they also said it was inconceivable that leaseholders in a building which had not yet been remediated at the time the BSA came into force would be protected, whereas those that had already spent their own money remedying defects prior to that date would not be, would be in a different situation, would not have any avenue to recompense I think there's, again, another couple of interesting points coming out of this. I mean, firstly, I think we see an interplay here between the statute, what the BSA says, and also the policy concerns, which is something that is kind of writ large over both the FTT decisions and the TCC decisions that Hugh will talk about later. So firstly, I think the language of section 124.2 provides that an RCO is an order requiring payments to be made for the purpose of meeting costs incurred or to be incurred. So the tribunal said, well, quite clearly, when that was drafted, the drafter had in mind costs that had been incurred pre the commencement of the Act and also post commencement of the Act. And there was further support for that in the explanatory notes which accompany the Act. And then also that if SDVP and Get Living were correct in their interpretation, this would lead to a rather perverse situation where some leaseholders are protected, and it could even be leaseholders in the same development where that's made up of a number of blocks, and other leaseholders are not, simply by the effluxion of time. And then the other key point to come out of triathlon is when it is just and equitable to make an order. So again, as you might be aware, the term or the phrase just and equitable appears on a number of occasions in the Building Safety Act, and up until the point of triathlon, there'd been very, very limited, if any, consideration given by the first tier tribunal as to what this meant in practice. And that there is no guidance within the BSA itself as to what that means or how the FTT ought to exercise its discretion. So in this particular case, the FTT decided that it had discretionary power to order an RCO, having regard to the purpose of the BSA and what it termed as all the relevant factors. And now there were a number of factors the FTT took into account, and I've just pulled out the primary ones there. I mean, it should also be noted that the FTT also said that it was well versed in considering what is just and equitable because it had long done so in other contexts, primarily in relation to service costs under other landlord and tenant legislation. And I think that's an important potential distinction there in terms of what the FTT will take into account and what the TCC might take into account, which again, we'll come back to a little bit later in this talk. But what the FTT said was that the policy of the BSA is that primary responsibility for cost of remediation should land on the original developer. And that really what they are concerned with is making sure the leaseholders are in a position where their flats or where they live is made safe as quickly as possible. They also said where there's a wealthy parent company or other wealthy entity which is called by the association provisions, you can't evade responsibility for meeting the costs of remedying the defects by hiding behind that corporate separation. So that's back to the point we made earlier about the power of BLOs and the power that the FTT and the TCC have to look behind the corporate veil. Tribunal also noted that it would give little weight to the fact, to the risk that major works would not be completed if it didn't make an order. It would effectively make an order in any event. And again, that's something we see repeated in the next case, the Secretary of State and Grey Living. And lastly, the tribunal said it's difficult to see how it would ever be just and equitable for a party that falls within the terms of Section 124 and is able to refund remediation orders to be able to claim that the work should instead be funded by the public purse, i.e. BSF funding or the cladding safety scheme. I think what's also clear, not on the slide there, is that the approach of the FTT is that these remedies under Section 123 and Section 124 are no-fault remedies. So the fact that there are claims or other potential claims applicants can make against other parties is not a factor that the court will, that the FTT will take into account when deciding whether to make an RO. It doesn't matter that in this case, the SDVP had originally sold the building. You know, they were still kind of ultimately responsible for those defects, and it was irrelevant that it had changed hands. What was relevant was that SDVP were the developer and that it's the policy of the BSA that developers be held responsible and or their associates. And lastly, that the motivations of the applicant are also of limited, if any, value when considering whether to make an RO. In this case, Get Living and SDVP tried to argue that Triathlon was making this application in order to avoid the costs of meeting the cost of the remediation order itself. The FTT said, look, that's irrelevant. What is relevant is that they have this power under Section 123 of the Act, and Triathlon can avail themselves of that to ensure the leaseholders are kept safe. And again, that is something that we'll see repeated in the next case, Secretary of State for Levelling Up and Grey GR Limited. So this is very recent. The decision only came out, I think, about 5-6 days ago, and it concerns a development called Vista Tower, which is a 16-storey tower block exceeding 45 metres with 73 individual flats. As was reasonably common, I think, in the late 2010s there, it was originally constructed in the 50s and 60s as office premises, as subsequently converted to residential use about 8 years ago. In 2019, the landlord was made aware that Vista Tower had significant building safety defects and combustible materials, in particular the cladding. And this case is quite unusual because by the time we get to the FTT, the fact that there are defects and remedial works are required is not in dispute between the parties. And in fact, by the time of the hearing in front of the tribunal, Grey has already commenced works and has 18 months left before completion. It has entered into a JCT form of contract with a contractor to carry out those works, and it has had some funding granted by the Building Safety Fund. Just quickly to note, this is a remediation order case, so slightly distinct from remediation contribution orders. Remediation orders require the landlord to actually, the relevant landlord, I should say, to remedy the relevant defects in the relevant building by a specified time. So we're not talking about contribution of money, and also the ambit of ROs is slightly narrower in that it's concerned primarily with landlords, and less so with kind of developers and their associated parties, which you see under Section 124 and the RCOs. So just very quickly to cover the parties' positions. Secretary of State argued that because all the pre-qualification criteria were met in respect of Vista Tower, it was entitled to a remediation order, i.e. there's no discretion there on the FTT. It's simply a test of have you met the requirements, and if you have, then you're awarded your RO. The fact that Grey had applied for funding was of no relevance, and the remediation order should still be made. Section 123, this goes to the discretion point, doesn't have a just and equitable test, which is correct. And if the tribunal did have any discretion, the applicant's view, so the Secretary of State's view, was that the tribunal should have forward funded the works rather than wait for BSF funding. Now, in response, Grey said that its parent company was effectively holding funds for a large pension fund, and therefore those monies shouldn't be applied to the and shouldn't be expected to be applied to the remedial scheme. There wasn't anything in the Building Safety Fund guidance that said they should do the works first and claim funding later. It's also not true that they could afford to carry out the works without obtaining funding. And that, and importantly, that a remediation order is akin to an order for specific performance, and therefore they don't actually need to make, the FTT didn't need to make an order in this respect because Grey was getting on and doing the works anyway and had a clear timetable for that. Now, what the FTT decided was that it had the power to, and a discretion as to whether to make a remediation order. The facts of this case, and in particular that there were works required and the situation of the parties, is much more relevant to the exercise of that discretion. The ROs are in effect a no-fault remedy. And so what the FTT decided was that A, it had discretion. So notwithstanding the fact there is no just and equitable test, there still remains a unfettered discretion on the part of the tribunal to award an RO, but that it would take into account the facts of the case and the works required. And in this instance, even though Grey were getting on and doing the works, the RO was still granted and was seen as a kind of reassurance to the leaseholders, a backstop, something that they could fall back on if Grey defaulted on its remedial obligations. So I think that brings to an end this section of our talk, and I'll hand over to Hugh. But just it's quite interesting there to see what the FTT does and doesn't take into account, and the fact that the FTT is very swiftly becoming a very powerful and useful tool for applicants, be that Secretary of State or leaseholders and freeholders.
Thanks very much, Ben. Just before I take over, just on that last point, I mean, what do you think? What, if anything, do you think that we can take more broad application from this decision?
Yeah, well, in Vista, I think what the tribunal has done, and it's consistent with what it's been doing. I mean, there's been 10, I think, remediation orders now, albeit this isn't our remediation orders. And a couple of RCOs. But what it has done here is really set down a marker that while it does have discretion as to whether to order an RO, notwithstanding that there's no explicit wording in the Act, that the safety of buildings and ensuring that they're remediated quickly and efficiently is the kind of overriding policy that sits behind the BSA. And I know that that's something that is also coming to the fore in the TCC decisions, and I think this is something that parties who find themselves on the receiving end of FTT claims should bear in mind when considering strategy and how far they want to go down the track of challenging them.
Thank you very much. Right, so I am going to have a whistle-stop tour through two cases, the first of which is URS Corporation and BDW Trading, a Court of Appeal decision. So this case relates to two developments built between 2005 and 2012, one in London and another in Leicester. It's a claim by BDW against the structural designers of those developments for allegedly negligent design. Now, this particular judgment that I'm going to be talking about isn't the final determination of the litigation. It was a decision about two things: certain preliminary issues that had been raised, and secondly, what we'll be focusing on in this webinar, but an application to make some amendments to the pleadings by BDW after the Building Safety Act had come into force. Now, the claim was begun by BDW before the Building Safety Act came into force, and it was based solely in tort. But there is an issue as to whether the claims were statute barred because of the passage of time. Now, the Building Safety Act extends various limitation periods, including the limitation period for claims under Section 1 of the Defective Premises Act. So once the Building Safety Act came into force, BDW sought to take advantage of that extended limitation period by, first of all, making a claim under Section 1 of the Defective Premises Act, but also making related amendments to seek a contribution claim under the Contribution Act, and also to expressly refer to the extended limitation periods. URS didn't give consent to those amendments, and BDW made an application to court. At first instance, it was given permission to make those amendments, and URS appealed, and that's where we find ourselves now. So the first point I want to look at is the question of whether the limitation periods under the Building Safety Act were available to BDW. Now, by virtue of the Building Safety Act, the limitation period for claims under Section 1 of the Defective Premises Act has been extended. So for buildings completed before the 28th of June 2022, it's now 30 years from PC, and for buildings completed after the 28th of June 2022, it's 15 years from the date of practical completion. And the relevant wording for this case is section 135.3. The wording of that is on the slide, and this effectively means that the amendments extending the limitation periods have retrospective effect. And that was accepted by URS. But URS said that whilst it did have retrospective effect, it did not apply to parties like them who were already involved in litigation when the amendments were made. URS effectively was saying it's not really fair to change the rules of the game when proceedings have already been started. Now, the Court of Appeal decided against URS. It said that the starting point was to look at the wording of the legislation, and it said the wording of that was quite clear. The key wording is that the amendments were to be treated as always having been in force. Second of all, it looked at a subsequent provision 135.6, which excluded claims which had already been settled either by agreement or had been finally determined by court or arbitration. And so it said that Parliament had already considered whether there should be exclusions to section 135.3. So that the effect of that was the extended limitation period for claims under section 1 of the Defective Premises Act is that they apply to all claims save those that have been settled already or have been finally determined. URS also argued that the Defective Premises Act was intended to protect lay purchasers only and not commercial developers. And the short answer is that the Court of Appeal said they were wrong. But looking at it in a slightly longer way, again, the Court of Appeal said that you had to start by looking at the wording of the statute and applying that to section 1.1. The straightforward grammatical meaning of the words was that URS owed a duty of care to BDW. It said section 1 didn't include wording limiting its application, nor was such wording to be found anywhere else in the Act. That being the case, there was no basis for introducing a significant qualification on the application. URS also tried to argue that the DPA required property ownership. They said that BDW couldn't make a claim under the Defective Premises Act because they had sold the buildings after completion at market value and therefore suffered no loss. But the Court of Appeal said that BDW remained liable to the purchase after the sale by virtue of the Defective Premises Act, and so would suffer loss, which they could seek to recover from URS by virtue of the DPA. So from a practical point of view, it was wrong on the factual basis, but they also said it was wrong in law because recoverability of damages under the Defective Premises Act is not linked and is not limited by property ownership. Now, whilst this is not strictly speaking a BSA point, the claims that I've seen so far under the Building Safety Act, because of their nature and because of the number of parties involved in the developments, invariably involve claims under the Contribution Act. The Contribution Act allows two parties who are both liable to a third person for the same damage to recover contributions between themselves. In this case, BDW had carried out investigations and remedial works without a claim being made against them by the owners of the flats. And URS argued that being the case, it wasn't open to BDW to make a claim for contribution because there was no contribution to be made. There was no claim for a contribution to be made in respect of. But the Court of Appeal rejected that argument, stating that there was nothing in Section 1 of the Contribution Act to the effect that a party's claim for a contribution doesn't arise until there is a claim against it by another party. The court then set out the requirements for a potential claim under the Contribution Act. Importantly, is BDW liable, or could it be found liable to another party? Equally, is URS liable, or could it be found liable to another party? And are their respective liabilities in respect to the same damage suffered by the same party? As long as those three requirements were met, then it was open to BDW to make a claim under the Contribution Act. That's where we stand at the moment, but things could change in the next year. The URS has been granted permission by the Supreme Court to appeal. That's going to be heard at the end of this year, rather than the 2nd to the 5th of December 2024, rather than 23 as it says on the slide, by a panel of 7 justices. So we can expect a judgment early in 2025.
Thanks, Hugh, and sorry to interrupt. I mean, I think that's really interesting, and it'll be. I'm a little surprised that they are choosing to go all the way to the Supreme Court, particularly on the points around retrospective effect of the DPA, which seem to me to be fairly kind of nailed on. But it will be interesting to see what the Supreme Court says about the contributions, the Civil Liability Contribution Act in particular. But very quickly. And maybe slightly unfair to put you on the spot here, but it seems to me that, well, at least in terms of the FTT, they were looking at retrospective effect, albeit in triathlon, albeit of in terms of remediation orders. Is there any crossover, do you think, between BDW and some of the issues that the FTT are considering?
Yeah, that's an interesting point. I think there's an important difference between the two cases and the legislation that they were looking at. The legislation that is the subject of the URS case has expressed provisions about retrospective effect, which you don't see in the equivalent provisions that the FTT were looking at in triathlon homes. So there is quite an important distinction between the two, but obviously the decisions get to the same point, largely possibly policy driven, not wanting to leave people out of leaseholders out of pocket. So there is an overlap, but there are also quite important distinctions between the two as well.
Brilliant, thanks, Hugh.
So the next case that I am going to look at is Wilmot, Dixon and Prater. Now, this is a well publicised case. This isn't what I'm not going to be talking about the final judgment. This is just a interlocutory hearing. the case itself is set down for 3 months at the start of next year, if it hasn't settled by then. It is a well-publicised case, partly because Wilmot Dixon have made a provision of over £60 million in their accounts as a result of the Building Safety Act coming into force. And they've been very vocal in saying that where they suffer loss as a result of defective cladding, they will be looking to their supply chain to recover that. In terms of this case in particular, Wilmot Dixon has already settled with its client by agreeing to carry out remedial works of just under £50 million, and it's seeking to recover those costs from 5 of its subcontractors and consultants. This particular interlocutory hearing was about an application regarding building liability orders. Building liability orders were introduced by Section 130 of the Act. The wording is there on the slide. They were originally thought to be aimed at developers who set up special purpose vehicles, SPVs, with very few assets to carry out projects. And once the project was completed, the SPV would be wound up and the assets transferred elsewhere. So BLOs were introduced to address this and stop leaseholders from being left without a remedy because the SPV had been wound up. It's worth pointing out at this point in time, we don't yet have a published judgment of this case. It's so new that we don't have a judgment. We're anticipating it, but all the information that we have on this at the moment is from Four Pump Court's website and an article written by one of the barristers involved in the case. The relevant facts for this application are that after intimation of the main claim, Prater and the Linde Group underwent a corporate restructuring. The publicly available information for those companies indicated that after the restructuring, they wouldn't be able to satisfy any future judgment because they didn't have sufficient assets. As a result of that, ACOM, another one of the defendants, issued a Part 20 claim for building liabilities orders against 4 Linde Group companies, 3 in Germany and 1 in the UK. ACOM saw an order that these companies would be responsible for any liability of the primary defendant, Prater. The 3 German companies wanted to delay the building liability order until after the judgment of the main claim. They effectively didn't want to have to argue something that they may never have to if Prater wasn't found liable. Now, the judge recognised the need to balance between the incurring costs now and getting an answer and delaying things until after the event when you may not need to argue about it at all. But it said that as a matter of principle, the Act doesn't require a party from whom a BLO is sought to be a party to the main claim or even a party to the proceedings at all. But if a BLO is sought before the resolution of the main claim, then it would generally be sensible and efficient for matters of the main claim and additional claim to progress together. So on that basis, in terms of the timing of the application, it was heard that it wasn't appropriate for the BLO issue to be deferred until later on. As for any concerns about incurring of costs, there would be no need for the companies from whom a BLO was sought to incur the same sort of costs as an ordinary defendant would, because they wouldn't have to argue all of the same points. Their costs would be limited to adducing evidence on only those issues relevant to the claim against them under the BLO, not the whole. They wouldn't need to put in expert evidence and factual evidence on the whole defect claim. We also understand that there is an issue, or the meaning of the word just and equitable in the legislation was also touched on, and what it meant. And although not arising from the application itself, the court did note that it was to be considered just and equitable, you didn't need someone to have acted disingenuously or dishonestly or otherwise to move assets to deliberately avoid a claim. You could dispose of assets entirely innocently in a group restructure, and it might still be just and equitable to award a building liability order against you. Second point, the Linde Group companies also argued that because the main defendants had the benefit of insurance that might cover at least part of the claim against them, that a building liability order wouldn't be appropriate. Again, the court disagreed and thought that it wasn't relevant in this case, albeit didn't rule out that it might be relevant in other matters based on the facts of the case. So again, a very interesting judgment. First time that BLOs have been addressed in proceedings, and whilst the judgment isn't out yet, we hope it will be out in due course, and more information will follow thereafter. And that is it from me on that point, unless we have some questions.
Helps if I come off mute. Fantastic. Thank you very much, Hugh and Ben. That's been really, really helpful last 15 minutes. Ben, when you started off with the background and context and the changing landscape of claims, I thought it was really helpful to sort of set the context for us. And then the detail of those 4 cases and the lessons learned from them, really interesting to see the direction of travel now. And with that, we have had a number of questions come in. I don't think we're going to be able to get to all of them. So what we'll do is those that we don't get to, of course, please feel free to reach out to Ben and Hugh, absolutely, to get in touch, and we can address those outside. But with that, let's take one to start with. Is it too early to identify any trends in decisions of the FTT or the courts in respect of the BSA? I'd like to field that. Any trends?
Hugh, do you want to take that one to begin with? I've got some thoughts.
Yeah, happy to. I mean, it's still very early days. I mean, we are, one judgment in for BLOs. I think Ben, you said there are 10 in respect of ROs, so still very early days. But I think what we can see is that, in addition to looking at the precise wording of the legislation, there's also clearly, both the TCC and the FTC, one eye on the overall intention of the Act to ensure that leaseholders aren't left out of pocket, and to make sure that kind of the right people pay. We can see that from the decision in BDW, where the court wasn't really attracted to the technical arguments put forward by URS, and also in the Wilmot-Dixon and Prater case, where the court indicated it wouldn't delay the issue of BLO. It wasn't So I think those two are really key points that the court will look to do what is right and what Parliament intended, whether or not they were clear in the precise wording they used.
Yeah, I think they're kind of very apt points here. I mean, the only couple of points that I would add is that I think we're going to see an increase in claims being brought by contractors and or developers against their supply chains, because when funding, for example, is applied for under the Building Safety Fund and under the Cladding Safety Scheme, so the two kind of primary schemes that are out there currently available to leaseholders to apply for funding to remedy their buildings, part of the conditions, I understand, attached to those grant funding agreements are that you use reasonable endeavours, I don't know what the precise language is, to go after those who are actually responsible for the defects and recover monies that way, and therefore so the money can then be repaid to the BSF. So I think we'll see more action there. I mean, that's quite similar to those for those developers who are signed up to the Responsible Actors Scheme as well. The Responsible Actors Scheme contracts, the agreement you've got to enter in order to become a member of that scheme, leaves open the possibility for the developers to pursue their supply chain too. So where they're undergoing remedial works, you can see that they will try and get their costs back that way. And that is, I suppose, chimes very much with the market, at least in terms of what you were saying about Wilmot Dixon. And then I think the other kind of key point is that maybe some of the arguments that we thought initially might be runners. So for BLOs, just an equitable test, you know, could you say, well, we're entirely innocent here, we've just acquired the building, or we haven't got any assets, but it's not because we underwent some kind of asset stripping exercise. Those look like they're going to be given very, very short shrift by the TCC. And then similar in the FTT, you would have thought in a case where you're getting on and doing remedial works, you've got funding, that you don't need a remediation order made against you. But in Secretary of State and Gray, we saw that the FTT ordered one anyway. So difficult out there, I think, for respondents to these types of claims.
Fantastic, thanks, Ben. Moving on to the next one. This came in early on. Under Section 85 of the BSA, is it now illegal to be occupying an HRB without a safety case report?
Okay, I can take that one. I mean, with the caveat that I'm not overly familiar with Section 85 of the BSA, but my understanding is that the wording of Section 85 and what it requires, kind of in that section of the BSA, if you like, requires to say, so the principal accountable person, the PAP, is now responsible for providing the safety case report. PAP is effectively being the person who's responsible for the maintenance of the common parts and the exterior structure of the building. So commonly it's going to be the landlord, or if he is hived off those obligations, it's going to be the management company or the residents management association, depending on the precise structure. But my understanding is there was a deadline in April for submitting safety case reports. If you don't do that, or if your safety case report is deficient in some way, the penalty is a fine, effectively, or potentially imprisonment. I don't think, but subject to doing a bit of further research, that it stops occupation of a building.
Great. Thank you, Ben. Another question here, possibly our final question. Will guidelines set out by the FTT about principles like what is just and equitable be binding on the TCC?
I mean, I think what we've seen from the FTT is useful. I mean, there's two important points there. One is the FTT itself isn't bound by previous decisions at first instance. So none of the principles, for example, decided in triathlon are technically binding on other cases. The same for principles decided in Way and Kedai, etc., etc. But what we see, particularly one of the things that struck me in the Secretary of State Gray decision, is there was a lot of reference back to the triathlon case, for example. So it's clear that they will take guidance, if you like, from those cases, but won't necessarily be bound by them. And then in terms of the TCC, I think there's a couple of important points there. One is they're not going to be bound by the FTT decisions. Two, they're going to be looking at the test of just and equitable in a different context. And this is the point that Hugh was making earlier, if you like, in terms of retrospectivity, that they are looking at a different statutory test in relation to a different aspect of the legislation. And then so they won't be bound by it, but they may well consider it useful guidance. And then lastly, the FTT very much exercises, when it exercised its discretion in relation to just and equitable, looked at other property law because that's its expertise and that's what it's used to. I don't know, but I suspect that the TCC might look at other legislations and not just property legislation where there is a just and equitable test. Certainly that was my working assumption pre-triathlon. Obviously it's helpful to have that additional guidance, but I think the TCC it isn't bound by it, so it may look further afield than that as well.
Great, thank you, Ben. Okay, we're just coming up to the hour, so I think that's fantastic. Thank you for fielding those questions, and thank you again for taking us through those cases. I'm sure everyone has hopefully found that very helpful. Thank you very much to the audience for joining us today. Before we go, just wanted to let you know of our next webinar in June. That's Thursday, the 6th of June, where we have partners Claire King and Mark Pantry, who will be discussing the recently released JCT Design and Build Contract 2024, Revolution or Missed Opportunity. Bit of a spicy title there. So what's different, what's new, what are we going to see with that? So please do join us on the 6th of June for our next webinar. The QR code there on the screen, that should take you to where you are able to register for that. So thank you everyone for joining today. It was great to be with you back here again, and we hope very much to see you on one of our upcoming webinars soon. Thank you again. Have a great day.